Welcome to the Ottawa Business Journal's live broadcast of Navigating the Economic Impact of Tariffs on the Workplace. I'm Michael Curran from the Ottawa Business Journal. Thank you for joining us today. We appreciate you being here and we hope to provide you lots of value. The announcement of imposition of tariffs on Canadian goods has caused an economic upheaval and concern for Canadians. Employers who have been or expect to be financially impacted by tariffs may be unsure about how to address the workforce changes that might be required. It's important for employers to understand their options and obligations as they guide their businesses through these uncertain times. Today, we continue our series of employment law considerations for employers. Here are some of the questions we will answer today. Are there government measures that will provide impacted employers with assistance? What can I do short of laying off or terminating employees? What do I do if I have to lay off employees? Hope not, but it might be a reality for some employers. And what do I have to do if I need to terminate employers? As we've done before, we are turning to the employment law experts in Ottawa for today's live broadcast. Eamon Harnden, LLP, is a boutique-style law firm specializing in labor and employment law with a focus on representing management in both official languages. Founded in 1987, this Ottawa-based firm now operates across Canada and is known for its expertise in areas such as employment law, labor relations, collective bargaining, and human rights. They are recognized as one of the largest firms in the National Capital Region, specializing exclusively in this area. Our expert today from Eamon Harnden is a returning guest. Please welcome Veronica Blanco Sanchez. There's Veronica.
Hi, Michael. How are you?
Great. I'm happy that you're back, and we're doing another live broadcast. And as is always the case, Veronica, your team at Eamon Harnden just nails the topic. Like the topic is so spot on for these. In the prep for this, Veronica, you and I were chatting about how this might seem, this point in time right now might seem familiar with employers who were wrestling with COVID-19 back in 2020. Any thoughts on that?
That's exactly right. There are some similarities. I don't want to say too many because I don't want to freak people out. But there are some similarities with what we faced during COVID, or what employers faced during COVID. And what I mean by that is that these are uncertain times. And that's something that we obviously experienced during COVID. So while the nature of that uncertainty is different in terms of from COVID than it is today, it is still nonetheless an uncertain time. So, I mean, we did learn some bits from COVID and what employers can do and mitigation strategies for uncertain times. So hopefully we can employ some of those measures to ensure a smoother process this time around.
Yeah, it's for those employers that went through COVID-19, it's like a resilience muscle, hopefully, that they've built up. And as you said, it's not the same, but there are some similarities. You know, we're not facing a health lockdown and, you know, kicking everyone out of the office and sending them home. But it's that economic uncertainty, right? Something outside the control of business owners, entrepreneurs, employers that is causing them, I mean, we hope not, but to consider maybe workforce changes. The other thing, and it's really the basis of today's show, there are some special measures that have been introduced for employers. And I don't know if it's just me, Veronica, you know, it's been such an intense news cycle with the new US presidency, a new prime minister, then general election. I don't think a lot of business owners, employers know there are these special measures exist, and that's really the value in people tuning in today. So, Veronica, I'm going to walk us through our quick agenda. We've, as we often do, divided this up into three tidy topics. Our first topic is what I just was talking about: government supports for employers due to tariffs. Yes, there are some, and we're going to talk about them. Number two, in our second topic, we're going to talk about employer measures short of layoff or termination. So if you need some savings, what can be done short of laying people off or termination. And then in number 3, we're actually going to talk about layoffs and termination if that's the only option. As is always the case, Veronica, we're going to wind up sometime around 12:25 with a live Q&A. So for all of you watching on YouTube and LinkedIn, please get those questions ready. You can ask them, by the way, at any point. They'll go into our moderation key, and we'll pick a few of those out for Veronica. All right, Veronica, without further ado, we're going to launch right into topic number 1. Once again, this is government supports for employers due to tariffs. Take it away, Veronica.
Thanks, Michael. Yes, so as you mentioned, yes, there are some government supports that have been introduced. While they're not necessarily the same or similar to what we saw during COVID, which focused a little bit more on the employment insurance and long-term layoffs of employees. There are some more targeted measures to assist employers during these uncertain times. So the main one of these is called the work sharing program. So this is generally intended to help layoffs where there is a temporary decrease in normal business activity, and that decrease is beyond the employer's control. So while this work sharing program has existed for quite some time with the EI and the federal government, there are some particular measures that are being that there are some additional reliefs to take advantage of this agreement by virtue of the uncertainty that the tariff and trade war has caused. So what this does is that this agreement provides income support for employees that are eligible for EI and are experiencing reduced workload. As for employers, they can take advantage of this and in turn pay a prorated amount of wages where approved for this program. So what this looks like is when there's a temporary reduction in a work week, and the remaining available workers are able to share the work that is available. So while usually everybody does 100% of their work and perhaps only 80% of total work is available, everybody does 80% of work. Some of the key things to consider is that the employee and union, where applicable, must agree to it. It's a voluntary program. And the second thing to remember is that the decrease of the reduction in work must be at least 10%, and that's usually measured in earnings. Now, the special measures that the federal government has announced for this program have been effective since March 7th of this year and will be effective for a year until next March of 2026. What this looks like is that the employer eligibility has been expanded. There are 3 primary components to this, and that is that the employers have operated for at least 1 year. It was formerly a 2-year operation requirement. So this now welcomes new entrepreneurs, businesses, and employers. Second, it also includes nonprofit and charitable organizations, as well as cyclical or seasonal employers, whereas formerly it used to be only for either publicly listed or private practice employers. And lastly, the employer's decrease in work must have occurred in the last 6 months. So these are, in addition to that, there's an extension of the maximum length of the work sharing agreement, where it was formerly a maximum of 26 weeks, that's 6 months. It has now been extended to a maximum of 76 weeks. Which is over a year, more than twice of that previous maximum. There is the same minimum period of time for the agreement, which is 6 weeks. So your work sharing program agreement must be a minimum of 6 weeks. The last third relief that's being provided through this work sharing agreement is that there is a waiver of the cooling off period between successive work sharing agreements. So formerly there was a mandatory cool off period equal to the same length as the agreement itself. So say, for example, you had an 8-week work sharing agreement in place. There was a mandatory equivalent 8-week period before you could engage in another work sharing agreement. So that has been waived. So to the extent that any employers have taken advantage of this work sharing agreement recently, and are now in a circumstance in which they're seeing a reduction or a need to reduce their workforce, then they can still take advantage of this option despite usually haven't been in the cooling off period. So those are some of the arrangement that the federal government has undertaken to assist employers in still maintaining some of their workforce, but relieving some of the pressures that they might be seeing as a result of these of changes as a result of the tariffs and the trade war. So again, just to highlight that it is a voluntary program. It cannot be unilaterally imposed by the employer. Employees must agree to not only the program in terms of the reduction, but also to the sharing of the availability of the work. One last thing to mention just on that program is right now there is an intention of a 10 business day application period. So while it has historically been closer to 30 days, they're trying to keep it within a 10-day processing time so employers can access that as quickly as possible.
Let me ask you a bit of a question, Veronica, on this. I don't think a lot of employers, I mean, maybe HR professionals are very familiar with work sharing. I don't know if the average entrepreneur or business owner is. So let me just give you back a scenario to make sure I'm grasping this correctly. And please, I'm sure I'll make some mistakes here. So correct me if I'm wrong. But let's assume it's a private sector company. Let's assume it's non-unionized, which is most of the businesses that we bump into at OBJ. So I've got two employees. Sorry, I'll start from the beginning. I've experienced a significant reduction in work as a business. My revenues have dropped 25%, and I don't have enough work for all my employees. So let's say I've got two employees. They were previously, full-time permanent employees working 40 hours. And now I say, well, look, there's only 40 hours total for these two employees. So what we're effectively saying here is you would go to those two people and say, I'm very sorry, there's some bad things happening in the company, revenue is dropping. We need to make some cut back on some costs. So I, as the employer, are going to propose that each of you work 20 hours a week. You'll share, and then EI will pick up some of the decrease in wages that they're experiencing. And I'll say one other thing that you said, I think that was really key here, is they must agree to this. So I can't impose this on the two employees. They must say, we understand the situation on an exceptional basis. We agree to this. We're going to go down for this period of time. Did I generally explain it correctly, Veronica?
That was actually perfect. Yes, I know you said you didn't have a lot of faith in yourself there,
Okay.
but that was well
Okay.
said. That's exactly it. And something that I will just caveat to that is the range in terms of what the federal government expects in order to take advantage of this program is that the reduction is between 10 and 60%. So to be kept within that range. It's not so once we get above the 60%. Well, that might not be it's not too much sharing anymore. So that's something to keep in mind as well. So while there is a minimum of 10%, keep it no more than 60%.
And I'll ask you one more question, then we're going to go on to the government of Ontario, the provincial change. So if in my scenario, both those employees agreed to that, then most certainly I should go to an employment lawyer to draft a letter and make sure that everything is copacetic, so to speak, and get signatures and sign-offs, correct?
That's definitely it, because what you want to avoid, and we'll talk about this a little bit as well, is a claim of constructive dismissal, right? You don't want the employee to then say, oh, actually, I see that you're trying to kick me out here. You're trying to have my pay. It requires a bit of a delicate, not only approach, but the procedure, the letter, the documentation, and the wording of that, implementing that can be quite unique. Not to mention, of course, the application to the federal government to approve the program in the first place.
Yeah, I could really see a scenario in my scenario where, these two employees, maybe it's one or both of them are 3 weeks, 4 weeks, 5 weeks into this, and they're like, this isn't working for me. and then they're trying to go back and negotiate some changes. You need to have this papered, as they say. Okay, Veronica, tell me about the government of Ontario. So the government of Ontario also has some special measures for companies that might be suffering from this current and looming trade war.
Yes. So what the government of Ontario has done has they've kept it on deferring some taxes and providing some rebates as well. So between April 1st, so this month, or I guess now last month, and October 1st of 2025, Ontario government's deferring certain provincially administered taxes. So it's a 6-month of deferral, and it's specific to 10 business-focused tax programs. These include some of the tobacco tax, international fuel tax, wine and spirits, employer health tax. There's a few. There are some particular taxes in there that are being deferred. And that is, the government is estimating that's up to $9 billion in cash flow support for these 6 months. So it's the first initiative that they have implemented to help employers undergoing some financial uncertainty or economic uncertainty. And the second one of these is that they have issued $2 billion in WSIB rebates for safe employers. So that is actually in addition to another $2 billion in rebates that they distributed in March. So they have doubled the amount of rebates that they are providing for WSIB.
That's great. By the way, we'll switch into topic number 2 here. For all of our viewers, a reminder that we'll go to your questions sometime around 12:25, so in about 10 minutes or so. Veronica, I really, and just ask those questions, whether you're on YouTube or LinkedIn, ask them away and we'll see them on our side. I like, Veronica, how we set things up, because this is kind of, here's the special measures. We're now going to talk about what employers should consider if they don't want to go for a full layoff or don't want to go for a termination. So let's move to topic number 2, employer measures short of laying off or terminating.
Right. So one of those measures would be the work sharing program, of course, outside of taking advantage of that opportunity or ability to take advantage of that opportunity. The focus really still is on employee discretion, and what I mean by that is being voluntary, voluntary changes to potential structures. And what I mean by that is either to the existing contracts, whether they would be open to a voluntary unpaid leave of absence, or lastly, could be a voluntary separation package. So again, you hear the word voluntary over and over. And I think something that maybe even we learned from COVID is the ability to have some say, or just having an open dialogue can ease a lot of those tensions that employees might be feeling. So that's why, in short of the unilateral imposition of changes by employers, which I'll discuss in the next slide, as in terms of the risk that poses, is to actually just involve your workforce and your employees in navigating what some of those preferences might be. So what is key here is, again, the need for it to be voluntary. Anything that is unilateral would be could cause a risk of a claim of constructive dismissal. So we want to avoid that. How do you avoid that? Is by bringing them into the conversation. Something to consider in terms of making some of those changes on even on a voluntary basis, it's something that's called fresh consideration. For those that may not be aware of what that is that anytime that you engage in a revised or new agreement with an employee, you have to provide them with a benefit that they don't already have. So the most common one of these is usually a signing bonus, or whether it's an increase in pay or an alternative benefit such as increased vacation more than what they're already entitled to. So once you have, making sure that you have that, otherwise that agreement is at risk of not being valid. So that's thing to keep in mind, but those three those three options would be the ones in the focus on voluntary. So that whether that's changes to the employment contract, I mean by that is whether it's hours, duties, things of that nature that could provide relief on both ends, and or an offer of an unpaid leave of absence. Now, something to keep in mind in that component is that under the Employment Standards Act, there are still obligations, even when individuals are on leave. There are obligations on employers to during that leave, and the primary one of those is you have to maintain the benefits that the employee is already entitled to. So, for example, the most common one, of course, is group health insurance benefits. You have to continue making those contributions and maintain them on the plan while on that unpaid leave of absence. So those are just some things to keep in mind. But as as I mentioned and you heard probably throughout, is the key of mostly being an open discussion with and giving the employees some control over those steps.
And it's fraught with risk, so you want to get the right legal advice as well. I wanted to pick up on a couple of things you said there. First, a fresh consideration. That's something I've learned that I never understood in our live broadcast with Eamon Harnden here. So that's really interesting. So you need to provide them with someone, as you said, either some remuneration, additional remuneration, or vacation. Maybe the one thing I'll ask you, Veronica, is just thinking again about the implementation of this. So if I was a business employer thinking about voluntary unpaid leave or even a voluntary separation package, do you have any advice on whether I offer that to particular employees one-on-one, or do I make some sort of public statement inside the organization? Are there any employment law considerations on, targeting a few people versus just generally letting people know this is something the company is considering?
Yes. So because the primary risk is a claim of constructive dismissal, and what that, for those who might not know that term, is where the employer is either imposes a unilateral change that's to a fundamental term of an employment arrangement, or in which the employer indicates that they no longer intend to be in the same relationship. So when you go on a one-on-one, you'd have to be extremely cautious to mitigate that. Then you do perhaps a broader, whether it's company-wide or department-specific, depending on who's getting impacted within the organization. But it could be a pretty big risk to go to pick and choose, because then you might not only end up with a claim of I was targeted for termination rather than a genuine offer of a voluntary change here. So you would have to be extremely careful to do any one-on-one. I would likely stay away from that and focus on a broader and showing really that this is not any one reason. It is a broad implication.
Okay, that perfect answer. That's exactly what I was wondering. And I understood, again, just your advice would be make it company-wide or make it like department-wide. So if I was in a manufacturing, it might be people, I hope it's not, but on the, the manufacturing floor, they're impacted, or it's the admin department or the sales department because there's not enough orders coming in.
That's exactly it.
Okay. Such practical advice. This is just really great stuff. All right. So a reminder again that we've got a chat going on our YouTube and our LinkedIn. So please get your questions ready. We'll be going to you probably in about 5 minutes or so. Our final topic, Veronica, is key considerations for layoffs or termination. So now, work sharing is not going to work. The voluntary thing's not going to work. Now, as an employer, you need to make some tough decisions. So it's either going to be a layoff or it's going to be a termination. Take it away for topic number 3, Veronica.
Absolutely. So on the temporary layoff component, which might be, the first step, even if you're thinking of a more permanent need, you could try a temporary layoff first. However, you want to be careful with that because although there are specific procedures under the Employment Standards Act. The Employment Standards Act does not oust what's called the common law. So the way that employment law in Ontario works is that we do have the ESA. Courts can say things otherwise. So unless the employment agreement limits things or permits things pursuant to the Employment Standards Act, you could see yourself not being able to take advantage of some of those ESA provisions. So let me break that down a little bit more. Under the ESA, employers have the ability to temporarily lay off individuals where there is a reduction in work. And that temporary component is that it may be up to 13 weeks within a 20-week period, consecutive period, or could be more than 13 weeks in a period of 20 weeks, as long as that layoff is still less than 35 weeks in a period of a year, one continuous year. Now, there are some conditions in order to take advantage of those temporary options. And that is, as I mentioned earlier, is a continuation of employer payments for employee benefits under retirement, pension, insurance plans, and whatever other plans might be in place or benefits might be in place. So while that is available, it is only available to those that whose either employment agreement permits it or that's it, whose employment agreement permits it. Because what's the courts have said is that under the common law, which is essentially what the courts decide and determine, any unilateral imposition of a layoff, which is of course a fundamental change, could still be constructive dismissal, which is ultimately a termination. So for those whose employment agreements don't provide for temporary layoffs or who don't have an employment agreement in place, this option is no longer available to you without the risk of a claim of constructive dismissal, which one thing we did learn from COVID is a clarification that employers cannot take advantage of the ESA temporary layoff provisions without the proper employment agreement in place. So one thing that might be positive outcome or a learning experience from the from COVID is that a lot of employers did put and update their employment agreements. But to the extent that there are new employers or you're not aware of the tension between the ESA and the common law, I just want to be cautious before actually employing or considering this option. Now, something to remember here then is to the extent that there are any terminations and permanent layoffs, is that I'm just mindful of the time here, but is that there are special considerations for mass terminations. And what that means is 50 plus employees within the same 4-week period. So while usually there are some statutory requirements in terms of what termination notice and severance pay, if applicable, are due, where there are more than 50 or more employees in the same 4-week period that are being terminated or laid off, there are additional considerations and unique considerations that you have to keep in mind. These include notifying the ministry and providing increased notice entitlements or pay in lieu of notice. So again, just to highlight here again, that this also depends on each employee's employment agreement, where the employment agreement ought to limit those entitlements to the ESA requirements. Otherwise, they could access what's called common law entitlements, which said could be, which in the termination sphere could mean greater entitlements than what the ESA provides for.
Okay, that's great. And just want to zoom out on a few things that you said there, Veronica. So in this section, so as it pertains to actual layoffs and or terminations, there are no special measures. We're back to the standard employment law provisions. Is that
correct?
Okay.
That's exactly it.
Okay. And then the other thing I picked up on, just to underline, you stated it well, is if you are considering layoffs based on, again, hopefully I get this right, judicial decisions taken during COVID, that you can't lay someone off unless there's a provision in their employment agreement that says they can be laid off. Did I get that right?
Yes, that's essentially it. There are some other access as well, but they're very specific, such as, for example, seasonal employees who that the work is seasonal or time dependent. But in the more standard permanent context, that's correct. It's a little
Okay.
in the simplified version, yes.
Yeah, as is always the case.
As is always, yes.
We're scratching the surface here. You need to call an employment lawyer to get details on this. We're going to shift into our questions. I've got my eye open. The one thing I wanted to ask, and it kind of picks up on the lessons learned from COVID. When I'm thinking, and again, I've learned this through these webinars with Eamon Harnden, there's always the technical aspects of law, and then there's the HR best practices, I'll put it. So maybe we could just spend a second, and I get that you're not an HR practitioner, you're the employer of law, but your advice for an employer that might be listening to this, Veronica, and thinking, I don't know how to work, so again, let's assume that an employer is experiencing a very significant decrease in revenue or drastic increase in cost because of tariffs. When they're easing themselves into this, any advice just on whether should they be completely transparent with employees? Should they start with their management team? Any sort of advice? Again, it's not legal advice, but just on how to approach these issues, because it causes a lot of stress for business owners, entrepreneurs, and employers. Any thoughts on that, Veronica?
Yeah, so I mean, as you said, this is a little bit broader than the legal sphere, which is fine. And I mean, it could depend on every workplace, the nature of each workplace, the culture of each workplace. Chances, if you follow your standard practices in terms of communication, then it lets people know that they're, that everything is in line with the way that the business already operates. So in terms of providing more information, or whether it's active announcements, I think that certainly has to be more of a case by case or business by business analysis and consideration.
Sure.
Something surely that we have learned is that by being somewhat of a, providing more transparency or more reasoning, it could provide some either relief or, appreciation from employees. But you want to be careful to not say things that could then backfire, in that you either have to, you bind yourself to things that you said at a time where circumstances were different. So you just want to be careful in that respect.
Yeah, I like that. There is that balance between like transparency and not shooting from the hip, being very deliberate by what you're communicating.
Mm-hmm.
Have other people, maybe there's a point, right? If you're an employer, make sure that other people from your management team, potential lawyer, potentially your financial advisors, are scrutinizing what you're saying, thinking about how others might digest that, might interpret that. And I think always acting with respect and empathy, right?
Absolutely.
Certainly if there's going to be workforce changes. Veronica, I'm going to throw one question up here on screen. I'm going to try to throw it up. Sure. There it goes. And I'll read it out loud so you can digest it a little bit. So Vignesh, thank you for the question. It says, if a company is negatively impacted by current tariffs and is undergoing business turmoil, what steps should the company or organization take to mitigate the impact, and how can the government assist in such situations? What key points should be kept in mind when addressing? So what I'm interpreting there, I hope I got this right, Vignesh, is as an employer, before I think employment cutbacks, workforce cutbacks, is there any obligation to look elsewhere? So should I be trying to find other costs, Veronica, whether it's, my real estate costs, or, is there a legal obligation to look elsewhere, or is it completely free and clear to consider workforce changes?
While, especially for the work share program specifically, in terms of what the federal government has done to try to ease some of these options, is that there does have to be some kind of proof of downturn in business activity and therefore work available in the past 6 months. So the way that this is being done is the easiest is to do the comparison, the 6 months here, say, versus the 6 months prior to that, or the year prior to that, whatever the case might be. And so there does have to be some kind of show. In terms of active need to cut elsewhere before turning to employment matters, I have not yet seen anything that imposes that active requirement of exhausting a certain list of other cost-cutting measures before turning to workforce cuts. We have not seen that yet. Obviously, that does not mean that doesn't stop each organization from turning to those alternative measures first. Absolutely, but I have not seen an active legal requirement in order to take advantage of any of the options that we've discussed here today.
Yeah, that's right. And thanks, Vignesh. I see your point on the proof of a turn down in the case of layoff. I'll give a quick shout out to Mike McCarthy. We won't get into yours because Veronica's on the employment law side, not a commercial lawyer. But yeah, for sure, you could consider, unloading properties, asset mixes, office space. I think that was something that was contemplated, Mike, during the pandemic. Veronica, we were conducting a poll on YouTube. I'll just share some of the results here. So we asked people, and we talked about this in the lead up as well, Veronica, saying that, unlike the pandemic, there are certain types of businesses that might be impacted more in this trade war than others. So we asked on YouTube, is your organization concerned about the ongoing trade war? 72% of our respondents on YouTube said yes. 27 said not sure. No one said no. So that's interesting to see those results. And I got one other question. I can't bring it on screen, but I'll read it aloud here. It's so we're asking about the biggest concern when it comes to managing workforce changes. The biggest concern, well, it was a bit of a tie. It was understanding legal obligations, Veronica. So that's why we're here today, and knowing the options. So I think hopefully we did a good job at helping people understand what is out there in terms of special government programs, and also thinking through the options in a very careful way. Veronica, I think we're a little into overtime, so we'll shift to our key takeaways. So help us wrap up, Veronica, and summarize what we've talked about here today.
Absolutely. So, there are various options. That's the first thing just to keep in mind, is that there are options. And at the same time, but those options have some corresponding obligations. They also have some risks, the primary ones being claims for constructive dismissal or wrongful dismissals. So in employing those different options, and what those are is whether it's the work sharing programs, the offering, different voluntary options, whether that's unpaid leave of absences, reduced hours or duties, or a separation agreement. You want to make sure that it's done carefully, and to being able to establish that it truly is voluntary rather than being perceived as unilateral imposition. So that's one of the options and concerns there. And then after that, when you are considering employing layoffs or terminations, there are unique circumstances, or you have to consider unique circumstances and options there in terms of whether you are legally allowed to employ some of those temporary layoffs, and if not, whether there are what termination entitlements might be due, which is both on the notice side and the severance side, as well as the risk of access to common law notice, which differs from ESA. And lastly, considerations on mass layoffs, so 50 plus employees within 4 weeks. Reminder that there are some unique considerations and obligations in that respect. So, of course, I'm happy to help if any of you are in need of employing or considering these options. Please don't hesitate to reach out.
That's great, Veronica. And again, I just want to underline the importance of doing things correctly here, because if you're playing out the scenarios that we've talked about today, and if you're a company or organization that's being very severely impacted by the ongoing trade war, if you don't handle these employment law matters correctly, I mean, you could be facing tens of thousands of dollars in legal fees and in payments to people. So if you think you're in a deep financial hole to start with, imagine, Veronica, if you didn't follow these measures correctly, right? And that's why the importance of having some professional advice on this. In fact, we'll bring up your contact slide. So if someone is in a situation where they need to contemplate workforce changes, we encourage you to reach out to Veronica and her colleagues and the partners at Eamon Harrington. Thanks, Veronica. Great job today.
Thanks, Michael. Appreciate the time.
As we placed on screen there, Veronica, there will be a playback of today. So if you're watching live and you need to share it with a company executive or HR person, that will be available to you in just a few minutes. Veronica, we hope to see you again. Thanks for everything today.
Absolutely. Always a pleasure.
All right. That was Veronica Sanchez from Eamon Harrington. You can check them out. I believe their website is ehlaw.ca. Also, a reminder that you can visit obj.ca, speaking of websites, every day for the latest in local business news. I highly recommend you subscribe to OBJ Today. That's a weekday, Monday to Friday email newsletter, and it has a summary of everything that happened in the day in business from a local business perspective. I know you might be thinking the last thing I need is another newsletter. I trust me, this will summarize the day's news very succinctly. You can glance at it for a couple minutes, click the link if you need more info. Follow us, please, OBJ on LinkedIn. We just eclipsed 40,000 followers. And if you're on a YouTube watching right now, click the red subscribe button. I think we're edging up to about 3,000 followers on YouTube, which is a great number. And you can hit the little red bell icon to get notifications of when we're live or when we're posting a video. Thanks for joining us today. Hope to see you real soon. Please take care, and good luck as we navigate these difficult times. Thanks, everyone. Bye-bye.